Good morning. I'm going to be talking about whether there is an expectation of privacy in cell phone data. And the short answer is, in light of how most courts have applied the third-party records doctrine, I believe this is a difficult argument to successfully make right now. And the data that I'm talking about is a little bit different than what Jerry and Janet were talking about. I'm talking about what is called non-content data. Now, the law enforcement can obtain non-content data under the Stored Communications Act, which is a 1986 law that allows law enforcement to obtain data from a provider of electronic communication under a standard that is less than probable cause. All they have to show in their application is that there are reasonable grounds to believe that the records sought are relevant and material to an ongoing criminal investigation. I think part of the problem here with this non-content data is what was available as non-content data back in 1986 is very different than what's available as non-content data right now. We certainly can access more than just cell phone numbers that are dialed. Your cell phone is close to a tracking device now with cell site location data. Google searches, you're doing all of those kinds of things. And so this, is arguably an example of where technology has certainly outpaced the law, and perhaps this distinction between content and non-content data is no longer valid. But going back to this issue of whether there is actually a reasonable expectation of privacy in the cell phone data, most courts have found that under the third-party records doctrine, there is not, because you are voluntarily conveying information to your cell phone provider, and therefore you don't have this reasonable expectation of privacy. In fact, just this month in U.S. v. Davis, which was an 11th Circuit case, the court sitting en banc reversed a 3-judge panel in Davis in which the court held exactly that. And in Davis, the government had gathered over 11,000 data points with cell site location data regarding Mr. Davis. And this data placed Davis in the vicinity of 7 armed robberies, which had occurred in a 2-month period. The 3-judge panel, who found that there was a Fourth Amendment issue, but then said the evidence was admissible under the good faith exception to the exclusionary rule, compared or analogized the cell site location data to a GPS. Because when you have such voluminous data, it's different than the prior phone data where you may have what's termed non-content data of me dialing a phone number from my home or even a cell phone. For Mr. Davis, for example, they had 11,000 data points, which comes out to about 175 data points per day. And so you could see where Mr. Davis woke up, where he went, throughout the day, and where he went to sleep. And so that cell site location data, the cell phone becomes more like a tracking device. That was the argument that was made, and becomes like a GPS, and therefore arguably you have a Fourth Amendment issue. The en banc court was not persuaded under the theory that this was information that was voluntarily being conveyed to the third-party record provider. There's also a district court opinion out of the D.C. Circuit in which the D.C. Circuit did find there was a Fourth Amendment violation under a similar theory, and it's the aggregation mosaic theory, if you will, where when you have so much data that paints a picture of an individual's whereabouts, it crosses the line into a Fourth Amendment issue. You do have a reasonable expectation of privacy, as opposed to the prior cases where you may have had an isolated incident of some third-party record, whether it's a banking transaction, a phone call that you made from your home. The second The second issue that I think is important here when you're talking about cell phone data that's different than the traditional third-party records doctrine, you have not only the volume issue that I was talking about, but also whether the information is truly voluntarily being conveyed. In the Davis case, they relied on Smith v. Maryland in part. And in that case, the government got dialed phone numbers through a pen register, and those phone calls were made from a landline. This was back in the day before there were cell phones. And in that case, the court held that there was no reasonable expectation of privacy because of the third-party records doctrine, and you were voluntarily conveying that information to the phone company. You knew that that information was being disclosed. In Davis, on the other hand, you had cell site location data not only from times when he was voluntarily doing something that may trigger or activate the cell site. This data is being continuously collected, like Janet was saying. You know, I haven't used my cell phone or haven't made a call on my cell phone for 3 hours now this morning, but I guarantee that it's pinging somewhere, and you could put together a picture of where I've been this entire morning. And so that was an issue, that was part of the issue in the Davis case. And it really wasn't specifically addressed. The court discussed that, we all know that there's a location aspect to our cell phones. And so, you can turn your cell phone off, or you could choose not to use it, or you could do all of these things so that this data is not being collected. But I don't think that really addresses the issue of the difference between the voluntariness of when I'm actually using my phone and transmitting data to the provider versus when my phone is just sitting here. And there's also a Fifth Circuit opinion on this issue as well. And this was a 2013 decision. And in that case, like Davis, the court found that there was no reasonable expectation of privacy based upon the third-party records doctrine. But it's important to note that the data in that case was much more limited. In that case, the issue that went up on appeal, the data that was dealt with was location data, but it was location data at the time where the cell tower, when the individuals were making phone calls, when they were performing some sort of voluntary action that was pinging that cell tower. So I think there's a distinction here to be made. Also, in the Fifth Circuit case, the court also focused on who was collecting the data, and they distinguished the Jones case that Janet was talking about, because in that case you've got the government affixing a GPS device to an automobile, and the court stated that that's different than when you're going out and collecting third-party records where an individual is voluntarily relinquishing that information to a third-party record provider. So, I think this is going to be an issue that's going to have to be addressed by the Supreme Court, because there are some differing opinions in the various courts on this issue. And I think in Justice Sotomayor's opinion in Jones, or her concurrence, I should say, and Justice, was it Sotomayor? In one of the concurrences in Jones, I apologize, one of the justices was saying that it may be necessary to reconsider the premise that an individual has no reasonable expectation of privacy in information voluntarily disclosed to third parties. And I think this is really what this non-content cell phone data issue is going to get down to, is do we have to re-examine the third-party records doctrine in light of these changes in technology to determine where individuals have a reasonable expectation of privacy?